Good evening and welcome back. I'm Teddy. It's 8:30, August 8th, 2026. Let me just check for the sound to make sure everything is clear. Shout out to the mom. All my other bears I call the grizzlies and the honey bears. I do not see that we are live. Let's just check. Now I see some numbers coming across. Hey, Vicky, my moderator. Welcome back to the Bear Cave. And let's see. I haven't sent out any notices. Let's see if I can just send one out to baby Juju while we are waiting. Let me just see if I can send a very quick email out before I start anything. Okay. Just hang on. But I wanted to go ahead and start. All right, so that is taken care of. Sound is good. Ooh, I need to just clear my headspace. And I sent out a quick notification to baby Juju. Maybe she's at work and may have to catch this on the replay. All right. It's Analyze This Mess. You know what? Let me just start with this. Little AC/DC. Thunder. Thunder. Thunder.
And I knew there was no help from you. Thunder. Sound of the drums beating in my heart. The thunder of guns tore me apart. You've been
Thunderstruck.
Walked down the highway, broke the limits, we hit the town. Went through to Texas, yeah, Texas, and we had some fun. We met some girls, some dancers who gave us good time. Broke all the rules, played all the fools. Yeah, right. at the knees. Could I come again, please? Yeah, the ladies want your kind. You've been thunderstruck. Thunderstruck. Yeah, thunderstruck. Ooh, thunderstruck. Shaking out the knees. Could I come again, please?
Have you ever been thunderstruck?
Yeah, thunderstruck. Thunderstruck. Yeah, said yeah. It's alright. We're doing fine. Yeah, it's alright. We're doing fine. Thunderstruck. Yeah, thunderstruck. Thunderstruck. Wow, thunderstruck. You've been thunderstruck. 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 You've been thunderstruck.
Gotta start it off with a little AC DC tonight. Thunderstruck. Well, that's maybe one way to describe the feeling. Tonight, welcome to the Bear Cave and Unwind with Teddy. Analyze this mess. D for Defendant's Emergency Motion. Evans versus Robertson. You are not going to believe this, but I have said anything is possible, and it happened on the very same day that the court filed ECF 175 and ECF 176. Let me just see how I want to say this. Good evening, everybody. Because apparently August the 6th was not finished with yesterday. I came before you with what I believed were two major developments in Evans versus Robertson, August 6th and August 7th. Magistrate Judge Elizabeth Stafford issued ECF 175, a report and recommendation recommending that default judgment be entered against the defendant. And then came ECF 176, an order addressing pending motions and opening the door to limited discovery, including third-party discovery. Those were major developments. But today, when I checked Pacer, I discovered something I had not seen yesterday, August 7th. And I had checked. I check in the morning and I thought, this is it, right? No need to check anymore. Well, today, as I said, when I checked, something told me, it's the weekend, just go ahead and, check Pacer. Just make sure, you've checked the boxes. I discovered something I hadn't seen yesterday. ECF 177. And apparently, somebody had an emergency. At least that was part of the title of this motion. The defendant filed emergency motion to stay early discovery pending clarification of the operative claims. Now, Mom, before I go any further, I want to make something very clear. A motion is not an order. Fair use commentary for education, for criticism, for news reporting, for teaching, for informational purposes, for entertainment. The defendant has asked the court to stay discovery. I have not shown you an order granting that request. And tonight, I'm not going to predict what the court is going to do. I'm going to do what we do here. Stick with the facts. Read the filing. This was a 9-page filing. I don't think I'm going to read all of it tonight. I'm going to show the entries on the docket. This I just really looked at today and not in full completion because I have been away most of the day. Look at what happened. Because this emergency motion raises two completely different issues. The first is substantive. How many claims actually remain in this lawsuit? The defendant wants to know that. The defendant says 1, but Magistrate Judge Stafford's new report and recommendation discusses 3 surviving claims. And here's what makes that particularly important. Magistrate Judge Stafford isn't some new judge who just arrived in this case and picked up the wrong folder. She wrote the earlier report and recommendation. She knows the procedural history. She knows what Judge Levy subsequently adopted. And when Judge Stafford issued these new rulings, she also had before her my later motion for leave to amend ECF 160 and ECF 166 my motion concerning limited discovery. So when the defendant says essentially, wait a minute, Judge Levy left only one claim, why is Magistrate Judge Stafford now talking about 3? There's an answer to that. The defendant is asking for several things, including clarification. I'm interested. I read what Judge Stafford's order or report and recommendation, ECF 175, and then ECF 176. But that's only half of tonight's story. Ultimately, what Judge Levy determines remains. This is a report and recommendation. One for default judgment, the other for limited discovery. Because the defendant didn't merely ask, "Court, please clarify the claims." She also asked, "Stop the discovery while you're doing it." And when you read this filing closely, you discover what kind of information the defendant is particularly concerned about being produced. Identity, registration, ownership, account control information. She argues that essentially, and we'll get to the docket, that once that information is disclosed, her anonymity cannot later be restored. You heard what was read in ECF 175 and the basis, part of the opinion of the court for default judgment. Now, we're getting somewhere here because that discovery wasn't authorized for entertainment. It wasn't authorized because I woke up one morning and decided I'd like to know more about somebody on the internet. The court authorized limited third-party discovery, and now, on the very same day that discovery was addressed, we have an emergency motion asking the court to stop it. But Mob, there's something else about this filing that has caught my attention. The timing. Because I was checking Pacer that day. I know when I first saw ECF 175, every time you access Pacer, there's a charge. There's a record created on your account. It's time-stamped. So I know when I first saw ECF 175. And I know that when I continued checking the docket later that afternoon, ECF 176 had not appeared until after 3:30 p.m. The court closes at 4:30. Hold on. And yet, ECF 177, the defendant's emergency motion, was also filed on August the 6th. It would have been after ECF 175 because the defendant includes page numbers as reference to ECF 175 that wasn't even on the docket when I checked at 11:30. August 6th. 9 pages. A motion, not e-filed, had to be physically walked into the court. Someone go through the electronic monitoring at the federal courthouse, take the elevator to the 5th floor, and then walk physically, because you just can't hand the guards a packet and ask them to file it for you. There are cameras everywhere in the federal court building. Everywhere. You have to go through a checkpoint first. Open your purse. Pull out your wallet. Pull out your driver's license. Stand there and let the federal officer look at you, look at your driver's license, and then look at you again in the face. Put everything in a gray, container, including anything that you plan to bring into the federal court building. If you have a telephone and you haven't left it in your car, you must check it in a locker with them. And then you can go upstairs to the 5th floor to the clerk's office. Think about the timing. This was all done after 11:30, before the court closed at 4:30. That's a 5-hour window from the time the draft was prepared. Allegedly, somebody drive down to the federal courthouse and file a 9-page emergency motion for the defendant to essentially stop this case from proceeding into discovery, to pause it, and should that go forward, and I just looked, She is also asking the court, allegedly, I'm not quoting it, we'll get to it. I looked at this quickly and something caught my attention. If the reproduction from the third party or the third parties that are subpoenaed, if those records are returned, that they should be sealed and that the plaintiff, myself, should not be allowed to see into the contents of those documents until and unless the court would allow and put them under seal. And I haven't even, read. I am just talking tonight. You can probably tell as much as I have to do and have planned over the coming days and weeks ahead. Another motion. Let us not forget procedures here, procedural for the federal court. If a party does not respond to a motion, if it's the 14 days, and unless there is some exception that I'm not aware of, or the district judge intervenes in this case, then as the plaintiff, who has now become aware of a motion that was entered on yesterday, it's dated that the entry was the 7th, but it was filed on the 6th. It has the court stamp. I'm going to show you. Then I would be allowed to respond to this emergency motion and be given 14 days. Put that on the side for right now. The court just filed a report and recommendation, ECF 175. If any party wants to object, there's 14 days for that one. Then ECF 176. If either party wants to object, it must be done within 14 days. And now comes ECF 177, at least 3 2 objections and or a response plus to the motion. And let's not forget, this clock is ticking down to the November 13th deadline, when for me, the plaintiff, limited discovery closes. And any delay, I just don't know. Another week, 2 weeks, another stay. More delays, that's what the defendant is asking for. Calling it an emergency. A emergency motion. A supporting brief. Federal rules case authority, page ID citations to a report and recommendation that had been entered that very day, August 6th. And a certification stating that the defendant personally checked every legal citation in the filing and served. Now, could somebody prepare a 9-page motion and a brief in a matter of hours? Certainly. Attorneys do it all the time. I'm not going to stand here or sit here, so that's what I'm doing, and tell you that couldn't happen. But when I started reading ECF 177 carefully, I did notice something much more interesting than its length. The defendant clearly knew about ECF 175. She cites it. She argues it. Cites page IDs. But listen to how she describes what comes next. She says, and I'm going to put allegedly until I put up the actual documents. ECF 175 states, a separate order will grant discovery. Later, she says ECF 175 contemplates a separate order authorizing that discovery. So the first will grant, then contemplates, future tense, but we now know what that separate order was, ECF 176. So tonight, I have a very simple question. What exactly was ECF 175, or when was it prepared? Because the document itself appears to give us clues. It knows about ECF 175, but its language appears not to account for ECF 176, and ECF 176 is important because that's where Magistrate Judge Stafford addressed the very motions and issues that provide additional context for what she had just written. Remember, I said ECF 175. Obviously, if I didn't, you know, on the docket was filed first. When I checked and I looked at, of course, you know, the end of it, talking about more, you know, to come regarding discovery, I thoroughly anticipated that it would come soon. Maybe they didn't come, you know, get uploaded at the same time. It's only 11:30. 12 o'clock. I'm not going to give you my exact time. I said after 11:30. So the court wasn't closed. So I was continuously checking, and I still hadn't seen anything. And then lo and behold, on the same day, late in the afternoon before the court closed, ECF 176 populated. I had been checking all afternoon. And I will tell you, at one point, thinking, well, maybe it's going to come, show up on Saturday morning or Monday. But I was checking. And then it showed up. That's why I could prepare my Analyze This Mess based on ECFs 175 and 176. So one would naturally wonder, have no proof, but the document points to something interesting. It doesn't seem to include ECF 176 because it speaks in such a way, will grant, contemplates, future tense, when ECF 177, the defendant's emergency motion, appears to be drafted. Can't be certain, but I haven't seen any mention yet. And again, the way the language is written, it's Saturday. Will something follow on Monday morning? An additional motion? Something more? Because there was a small window, 5 hours. I can absolutely say 5 hours on Thursday. From the time it was uploaded and the time the court closed, that was a 5-hour window. The appearance. And somewhere after that filing appeared, the defendant or someone responded with a 9-page emergency motion, physically went to the courthouse and filed it. So that's a second. Not that it just made me, when I saw it, like, when was this filed? August 6th? When I saw the date? I said, you've got to be kidding. That means the court's report and recommendation caused such an urgency in the defendant's day that she paused, or someone paused, and had to get in a response, a motion, emergency motion, filed to the court straight away. Before. And The clock is ticking. I have been given the green light to conduct limited subpoenas to be served. And before the ink even dries, I'm not going to give anyone my plans. But this is the weekend. It's not a businesses are closed. And before the close of business on the 6th, the defendant had already filed a motion. I have said I don't underestimate anything. I don't. That's the legal system. And that's why I've said procedurally, motions we have learned, if you don't respond to them, the court can see them as, not necessarily as an admission, but that they were unanswered. And the court can then rule. And thank you, FIVA, for the $50 super chat tonight. Thank you, Vicky, for the 440 joules tonight. Alert. I'm not going to tell you tonight who prepared this document. I'm not going to tell you how it was prepared. I'm not going to tell you whether anyone helped prepare it. I don't know. Everything that I'm saying is being recorded. And I have no plans to say anything that's I can't document with some facts or give my disclaimer about addressing it. And when I don't know something, I really don't know something, I don't turn suspicion into fact simply because it makes a better YouTube story. We've got enough actual mess. We don't need to manufacture any. What I'm going to do is put the docket in chronological order, because once you see it, what appeared and when it appeared, you'll understand exactly why ECF 177 caught my attention. So pull up a chair, get a beverage to drink. I usually say get some wine, or, I have my Gatorade. Get whatever helps you survive this federal civil procedure, because tonight we're going hour by hour now. Let me take this down. ECF 175, ECF 176, and then ECF 177, D for Defendant's Emergency Motion. Let's go to the timeline. Take a quick break. All right, so before you, you can see ECF 175. It was filed August 6, 2026, report and recommendation. This is on PACER. ECF 176, filed and entered August 6, order on motion for leave to file, and defendant's motion, emergency motion to stay, ECF 177, filed August 6th and entered on August 7th. All right, so let's pull it up and then we'll at least look at the first few pages. In the United States District Court, Eastern District of Michigan, Southern Division, Sabrina Evans et al., plaintiff versus Daniel Robertson et al., defendants, case number 24CV 13435, Honorable Judith E. Levy, Magistrate Judge Elizabeth A. Stafford, defendant's emergency motion to stay early discovery pending clarification of the operative claims. So let's see what this is about. And I've been on now 50 minutes before getting to this point. We're doing okay out there in the comments, all right? Defendant, the individual sued under the disputed designation, Daniel Robertson, respectfully requests a temporary stay of all early discovery, including the issuance, service, enforcement, and production of any third-party subpoenas contemplated by ECF numbers 166 and 175 until the court clarifies the precise claims or claims remaining after ECF numbers 138 and 173. ECF number 175 states that 3 claims remain based on ECF numbers 75 and 112 and relies on that 3-claim description in discussing prejudice, identity disclosure, default judgment, and discovery. Let me just pause here for a minute. Well, let me just go to the end of that. But ECF number 173 later adopted ECF number 138 and granted defendants' later motion to dismiss in part. Thus, there is only one remaining claim, not 3, which is important as it pertains to discovery and subsequently any possible default. I filed a motion to amend and supplement the complaint. The court responded to that in ECF 175, 176. Specifically in ECF 176. All right. I don't see where there was any reference just yet to ECF 176. So I think you now understand why I made reference to when the defendant drafted and filed the emergency motion, composed it. What did she base it on? We'll see that right here in this motion, ECF 177. Okay. Because discovery must be relevant and proportional to the claims and defenses actually remaining in the case, the scope and necessity of any early discovery cannot be properly determined until the operative claims are identified. Federal Rule of Civil P 26B1, early discovery also requires court authorization before the Rule 26F conference, Federal Rule Civil P 26D1. A temporary stay will preserve the status quo without causing the loss of evidence. In contrast, disclosure of identity, account registration, ownership, or account control information could not be undone after production. Again, take note of what the defendant is asking here for the court. Respectfully requests or requesting temporary stay of all early discovery, including issuance. She wants to stop it before it is even issued. Service, enforcement, and production of any third-party subpoenas contemplated by ECF numbers 166, 175. But 176. Did I say 176? That's 166 and 175. Not 176. This is page 2. Defendant therefore requests that the court 1. Stay the issuance, service, enforcement, and production of all third-party subpoenas contemplated by ECF numbers 166 and 175. Clarify the precise allegations, statements, and theories remaining after ECF numbers 138 and 173. Limit any later discovery to matters relevant and proportional to the actual surviving claim or claims, and alternatively require any production to be made first to the court under seal and not disclosed to plaintiff until further notice. This motion does not concede valid service, personal jurisdiction, use of defendant's legal name, or waiver of any previously asserted First Amendment or Rule 12 objections. Wherefore, defendant respectfully requests an immediate temporary stay of early discovery until the court clarifies the operative claims. Respectfully submitted. Individual sued under the disputed designation Danielle Robertson. Defendant pro se at the registered agent in Phoenix, Arizona, and the Proton email address. There's more. Let me just pause. That was through page number 3. It's 9:30. Hold on, let me just put a cover up or switch this out for a second. And there we go. Put my stars back up here. That's a big ask. That's a huge ask within hours on the same day as the court filed report and recommendation 175 and limited discovery ECF 176. Let me come out for a moment, as I've been on for an hour. Let's see. Back to the bear cave. Good evening, Polo's Porch. You can also email me right now at unwinewithteddy@gmail.com. This is Analyze This Mess, fair use commentary. And Wayne Norman comes in again tonight. Welcome once more to the Bear Cave. And hello, Tigerlicious. Good evening, Teddy. Well, good evening to you. And you're saying to the rest of the Bear Cave, Vicky and Juju. She gave you a jewel either knowingly or unknowingly. Take care, you'll be okay. Ivy Jacinta, good evening, Teddy, Mom. I have missed a lot. You're catching up. A lot has happened in only 2 days. And before we barely gotten started, the defendant has filed this emergency motion to stay discovery. I've just read it in portion today. All right. I can stop it there. And I think I will. Because I've said a lot already. An hour full. I have. And I have also mentioned that, tomorrow. The court has issued the report and recommendation, and the court has also issued this. I read from it yesterday. ECF 176, order denying motion for leave to file proposed amended complaint, granting motion for leave to file third-party subpoenas and scheduling period for discovery. It addressed ECF numbers 160 that I filed a motion and my motion for limited subpoenas, ECF 166. The court inside of 176 addressed the claims again. Here on page 3965, page 4 of 6. It reads, the court also finds that Evans' goals for amending her complaint will be moot if Judge Levy adopts the report and recommendation to enter a default judgment against Robertson. ECF number 175. With a default judgment, Evans will have a chance to show her entitlement to damages and injunctive relief based on the claims that survived Robertson's motion to dismiss. 1. Copyright infringement stemming from the use of Evans' likeness. 2. Defamation stemming from Robertson's alleged post and about Evans' professional misconduct, false reports to police, and post, including body cam footage. And 3, cyberbullying and harassment stemming from Robertson's post about Evans' divorce. Page 3946. ECF 175, or it refers to the same document. That's all I'm going to read. I've read this entire ECF 176. It was addressed in ECF 176, but the defendant has filed an emergency motion to stay discovery until the claims are, for her, clarified. That's what she's asking. So clarification for everyone. Yeah. This is a different case than the other case. I've said it. It has been since December 23rd, 2024, when this case was filed in a federal court. There were 6 claims at issue. And as of this latest report and recommendation, it's been narrowed and recommended to the 3. I'm not going to sit here and argue through my 160 or everything else now that I could read at some point. The theories, my arguments, and the court clearly, put in the, filings ECF 176 addressing ECF 160 and 166. In 160, I had talked about all of the claims again and put them before the court. I'll say that much. D for distraction and delay. That's a real D. D for distraction and delay. Just when I thought, I'm into the weekend, just pouring my coffee, calm for the rest of the day, in and out today, ready to come back and continue the work that I have been legally granted discovery, limited discovery. And the defendant wants all of that to come to a halt. Even after, let's go back. I am going to go back to ECF 175 for a moment. Let me see if I can find it. It should still be up. And let's go back here. This is ECF 175. This is page 10. Applying these factors, default judgment is proper. Here, the magistrate judge wrote. For the first factor, to qualify as bad faith, willfulness, or fault, A party's conduct must display either an intent to thwart judicial proceedings or a reckless disregard for the effect of her conduct on those proceedings. There must be a clear record of delay or contumacious conduct that is perverse in resisting authority and stubbornly disobedient. Robertson has stubbornly disobeyed Judge Levy's order for her to disclose her identity. And a court order must be obeyed by the parties until it is reversed by orderly and proper proceedings. The defendant wants to continue to defy the court's order, stubbornly disobey. Contumacious, not my words. It's written in ECF 175. Even if an order is erroneous, the remedy is to appeal unless effort or enforcement of the order is stayed. She's filing an emergency stay. But this is referring to what was in the past. Judge Levy twice ordered Robertson to disclose her identity, and Robertson defied both orders. ECF number 118 and 124. Litigants like Robertson who make private determinations of the law and refuse to obey an order generally risk criminal contempt, even if the order is untimely or ultimately ruled incorrect. True, a party may try to avoid a finding of contempt when complying with an invalid order would necessarily result in an irrevocable and permanent surrender of a constitutional right. This exception has been applied when a witness refuses to testify about information implicating the Fifth Amendment privilege against self-incrimination. To justify her continued defiance, Robertson repeats her argument from her October 2025 motion to dismiss that the orders to disclose her identity violate the First Amendment protections against unmasking anonymous online critics. In litigation involving anonymous internet users, courts have weighed the validity of the claims and the plaintiff's need to uncover the user's identities against the First Amendment's protection of anonymous speech. But Judge Levy's determination that Robertson must disclose her identity is the law of the case and may not be revisited absent extraordinary circumstances. We're still waiting for the defendant's identity, her legal name, and her postal address. And it has come down now to discovery as the next step. I have been granted that because this case is being, well, the court has said things about it. Let me continue. A prior ruling may only be reconsidered where substantially different evidence is raised on subsequent trial. 2. Where subsequent contrary view of the law is decided by the controlling authority. Or 3. Where a decision is clearly erroneous and would work manifest injustice. Robertson seems to argue that Judge Levy's orders for her to disclose her identity were clearly erroneous and would work a manifest injustice, but her skeletal arguments fall short. And Robertson waived her First Amendment argument by failing to assert it in any of her previously filed briefs about the anonymity. Robertson made no First Amendment argument in seeking a protective order preventing Evans from obtaining discovery about her identity. Robertson did refer to the First Amendment when opposing Evans' motion to strike filings Robertson made under her alias, but only in a fake quotation misattributed to Doe v. Porter. Robertson also made no First Amendment argument in her objections to this court order for her to disclose her identity. Two, addressing the second factor. Evans has been and will continue to be prejudiced by Robertson's obstinate refusal to disclose her identity. I just read from ECF 177, a portion of it, the defendant's emergency motion to stay discovery in lieu of claims to be clarified. Evans has been and will continue to be prejudiced by Robertson's obstinate refusal to disclose her identity. 3 of Evans' claims survived Robertson's motion to dismiss. I've read those. Robertson has taken pains to hide her identity. Pains, motions. We have filed multiple motions to compel. The court has granted those motions. I have filed motions to show cause why the defendant should not be held in contempt and punished with sanctions. The court ruled on that and described why she arrived at her recommendation for default judgment. This is part of it. Robertson continues to disobey, defy, and stubbornly, as the court has said, not me. I'm reading from the court's order. I have not characterized Robertson as stubborn or contumacious. And any other adjectives that the magistrate judge. But this is causing me, the plaintiff, as the court has recognized, prejudice me. And this will continue to prejudice me, the plaintiff, in moving this court case forward and identifying Robertson. I have a right as the plaintiff who has spent nearly more than a year and a half in litigation, motion after motion, stays, report and recommendation. And finally, I have been patient and waiting and pursuing justice in this case. This case, my case, Sabrina Evans' case versus Daniel Robertson's case, is complex. I have said that. This default judgment recommendation is coming after months, over a year. Hang on. A year and 8 months. We're 4 months away, almost, to the 2-year mark. And I have a deadline for limited discovery, and it's November the 13th. Just a month and a half or 10 days shy of the 2-year mark. And the defendant wants to further hide her identity. That's what it is. The court put it here. Robertson has taken pains to hide her identity. Hide. I can clearly say it. The court has said it. This is not defamation. This is facts. The court has seen numerous records. I don't have to argue it. It's all in 100 and now 77 different briefs that have been filed in my case. Most of it. This is on the merits, and now because the defendant has disobeyed the court numerous times, non-compliant, defiant, stubborn, and taking pains to stand in the way of her identity being unmasked. And that's what it is. It's legal terms. This isn't for entertainment. I have filed my case. To continue to argue, and the court characterized it as the defendant being a shadow. I say ghost. I have been litigating before the court in good faith, in hopes that the court would eventually obtain the identity, because arguing before the court in this case, and for what has been done to me by a ghost, an anonymous ghost who I don't know the identity, neither does the court know the identity. It is pains that she is doing this deliberately. Above, she thumbed her nose multiple times at YouTube. That's in my filing, so I'm not making it up. With evidence. This defendant, with evidence, I put it in my case. You'll have to read it, and I will eventually read some of this. Has used multiple aliases to file copyright complaints to the Copyright Complaint Board. Numerous emails, numerous identities, aliases, multiple alias account names. This defendant has said she will never be found. I have the recordings. She has said she's going to get away with it. She has said she is going to be able to persuade a judge. She has said that if she ever thought she was going to be found out, her identity, that she was going to disappear. That's all part. These are the things that people who don't know my case, haven't read, don't know, haven't a clue what my case is about. And today, right now, we are still dealing with this anonymous, unmasked individual. I am speaking. I am not stumbling over my words. And this has all been put into the records before the court. I have said that there's ups and downs, it ebbs and it flows. Hold on, let me get some water. I am not trying to circumvent the law and fairness. That's not what this is about. Both parties, in all cases, defendants and plaintiffs in this country, thank goodness for the United States of America court system. You can disagree with it. It hasn't always come down the way we want it. But there is a system of laws here in the United States of America. And I'm an American. I'm a Black American. And here I sit and do not know anything about this ghost of a defendant. It's been hidden. She said layers have been put into place so that she cannot be found. It's been entered into my case. The defendant has said, if anyone who is on the account, and I'm paraphrasing this part, because these are all anonymous people. It could be one person, I don't know. So I have to say that. She has put it in such a way. She's anonymous. So she can say anything that she wants anonymously. So listen carefully. She has said in a recording that I have and in transcripts that I've submitted to the court in my case, should she or someone be questioned, they are going to deny even knowing who she is. That's an anonymous person denying another anonymous person. I have been granted the legal authority in limited confines, structure, to pursue subpoenas and have them served to third parties with the aim of unmasking, obtaining Danielle Robertson's true identity. She's also said that layers have been put into place and that it would take the police, the law enforcement, to find her, to identify her. This individual, this Anon, who so calmly refuses and takes pains to hide her identity, laughs, and even the court in this said on page number 9, ECF number 175, although entry of default is a drastic measure, the district court does not abuse its discretion in entering a default judgment to punish a party for egregious conduct and to deter other litigants who might be tempted to make a mockery of the judicial proceedings. This would make a mockery out of the court, a mockery out of justice, judicial process. And she has laughed in the face of it. I have the recordings. I have the recordings of her taunting me and laughing and saying that for the rest of my life, she is going to basically stand in the way. I want justice. I want to know the identity of this ghost who haunts, who said she's going to haunt me even after my death. No one on this platform, and I mean no one, who has come up against Danielle Robertson has faced anything close to egregious as I have on this platform. It's documented, it's written, and I simply want to be heard. And this case to move forward. And procedurally, we need the identity of Danielle Robertson. There are things that I can't even and won't even repeat. It just pains me and takes me to a place. I've never faced anything like this in my life. And I need God and His sword to go in. And I ask Him to take my hand and walk me through this process and through the door. And to identify Danielle Robertson, wherever she is on this earth, to make it known. Because she is standing in the way and doing everything she can do so that won't come to fruition. Danielle Robertson is not her legal name. Danielle Robertson is not her legal name. Danielle Robertson is not her legal name. Read between the lines. This is we wrestle not against flesh and blood, but powers and principalities. This is, I need a miracle. And I need God to give me grace and steady and hold me. Because these shackles, not physical, whatever, these shackles need to be broken. And absolutely, this needs to be resolved. In Jesus' name, I pray. Amen. Yep, I'm going to pray. Put something there too. Now, let me finish up, come out. I don't. Hmm. This is unbelievable. Yes, and I'm not ashamed. You can play this to the courts, you can play it to the president, you can play it to kings. I don't care. I'm being very transparent tonight. I'm serious, and I am in my right mind. My name, my life, my profession, my family, all of that is on the line. My dignity, my legacy. And she said she's going to ruin my legacy. She did. Or he did. I don't know who this person is. So let's wrap this up. Read the comments from down below and then check my email. And then I need to, move on for tonight and just decompress. And yeah, so I have much ahead of me and things to do. I appreciate all of you who joined me tonight. Blessed says, I don't know her, but I know my God and what he has done. Jack, I'm protected in his blood. Thank you for your comment. I have to be discreet. Okay. There are some things that I'm going to go on my members only. I think it would be better. Just certain things over the next coming, this week. We'll talk a little bit more. Depending on what I can get done tomorrow, I may or may not come back. If I come back tomorrow, it might be for a meltdown. It'll be Sunday. So I definitely need to meditate and pray and ask God for his help, for his guidance, for his forgiveness, for him to make a way out of no way. He is making a way. Let me go to the top. Again, thank you for the Cash Apps and Super Chats. I appreciate that. And last night again, Suri, thank you for your contribution to this channel. It was very generous. Thank you, Fiva, for the $50 contribution tonight. I appreciate you. Thank you for supporting this channel. I'm just looking at comments that I want to read. I may not acknowledge every comment. I need to, go through some of this. Ange, good evening, and Suri again tonight. MJE, thank you for stopping by. Wayne Norman, thank you for stopping by. I'm not at liberty to discuss, like, I don't want to discuss real legal details, even with someone who says they're an attorney. I wouldn't, discuss that here um, in my case. So I just need to be. Um, oh, let's see. Ivy, thank you for stopping by. Uh, Annette, as always. Yeah, Elvis Presley. Yeah. Thunderstruck. We started with that one. Ming Lee, good evening. Bless says, we scare Miss Teddy. We's not free yet. We's enslaved by our own race. Um, everyone in this country is entitled as to a fair trial, fair hearing. And this is not a trial by jury, it's the court. Karma doesn't expire. Yes, read the room. I'm just seeing some comments now. Teddy, for peace and justice, a delay isn't a denial. Keep the course, absolutely. Thank you, chat. Have a blessed night. Stay focused. It is now 10:24, and that will do it for tonight. I am going to check my email, and while I do it, yeah. Oh, I don't think you heard me. Let me remove the mic. I said I was just talking to you. My bad. Or I didn't uncover the mic. Hang on. I have checked my emails and I will get to all of them. Doesn't necessarily mean I will respond in kind just yet. I need to consider everything. And for those of you who aren't aware, over the years, I have received numerous emails and people reaching out, and I've learned along the way, and I'm still learning, I need to just be cautious in responding to, you know, things on email. Not that I won't, but I need to be cautious. I have experienced some things that I won't even share on emails, and it just has caused me to be the way that I am. And I need to be, especially now, especially now, especially now. So please be patient. All right. Thank you. Enjoy the rest of your weekend. Enjoy the rest of your evening. Biggest bear hugs go out to all the grizzlies and the honey bears. Please hit the like on your way out. It's just about 10:30. Thank you for watching and listening. Keep your bear phones on. Check the community wall. And thanks again to my moderators and all of you who have contributed to this channel. Thanks for watching. Until next time, I'm Teddy. Good night.